Okay, folks, I think we can go ahead and get started. It's 2:05 from my watch. Super excited for everybody to be here. My name is Drusilla Tickner, and I am a policy and advocacy strategist and attorney with the ACLU of Texas. The ACLU's mission is to defend and expand civil rights and liberties for everybody in Texas, no matter who you are and where you live. And we are here with some amazing partners that are listed on the screen right now: Center for Reproductive Rights, Lorraine Project, Planned Parenthood, and Morrison & Foerster, we've all come together to bring this very important lawsuit that we're going to talk about more today. To give you also I'd like to say that my pronouns are she and her, and I'm based in Houston, Texas. To give you an overview of what today is going to look like, I'm going to talk a little bit about how we got to this moment, and then we're going to switch over to a panel of some of our lead litigators on this case, who are amazing legal minds and who have really put together this incredible litigation that is so important for everybody in Texas, no matter if you currently need abortion access or not. And then we're going to open it up for Q&A. So that's your opportunity to ask questions of the litigators. You can either put it in the chat or you can put it in the Q&A box, and we'll get to it. And if at any point you have any questions, put your questions in the chat, and we'll either try to answer them as we go, or we'll answer them at the end. Or if you just want to have conversations in the chat, please feel free to do that too. We want to make sure that this is as interactive as possible. So with that, I'm going to go ahead and get us started with how we got to this moment. So abortion access in Texas has been under attack for, over a decade, really, in a really concentrated way. We saw some really terrible bills that are still in place now that restrict access by making people wait 24 hours, for example, requiring them to have sonograms, requiring doctors to give false information when when somebody has to have an abortion. The ability to get an abortion in Texas is already really hindered. But that 10 years or so, 12 years or so of attacks has really culminated into this point where we are today, where this bill that was just passed in the last legislative session is the most egregious abortion bill, restriction on abortion, that we've seen since Roe v. Wade was decided almost 50 years ago. We're going to talk a lot more about what this bill is and its implications in the panel. But before we do that, so just, I'm not hiding the ball. It is a 6-week abortion ban, and will restrict the access for most people who need care in Texas, who end up getting care after 6 weeks. But we'll go into the details in a minute. Before we do that, I want to show you a little bit about our advocacy journey. I think we often, hear that bad bills are filed, and then we hear that we sue about them. But we don't always see the journey of the advocacy moment. I think a lot of folks here were probably involved in that. So we're going to get started. If I can figure out how to work my PowerPoint. Here we go. So this webinar is called From the Streets to the Courts, and we really were in the streets all legislative session long. This is our first moment where we dropped banners in Houston, Dallas, and Austin to show that this bill was, to try to raise awareness with this bill and to activate our activists like y'all on the Zoom today. We have a cool video about this, but I decided not to show it. And here's some snippets of our advocacy work and dropping those banners. This was out front of the Capitol during our hearing in the House. We had advocates on the inside testifying against this bill to try to raise awareness with the committee members. We did lobbying of those members. We had people calling in and day out to say that this bill wasn't what Texans wanted. And then we did this demonstration outside of the Capitol where we videoed it to make sure everybody knew that abortion was healthcare. And it is. Abortion is healthcare. This is at a press conference. We made sure we raised media awareness. We got doctors' voices out there. We had advocates' voices out there, and elected officials. And we were really trying to raise the narrative around abortion access in this bill. We did another banner drop within the Capitol. This was one of the most fun moments I think we've had, where I love doing direct actions, and this was a really great one. And we got to show our artistic ability. These banners are so cute, in my opinion. But while we were banner dropping, while they were taking the vote at the legislature, our champions were standing up for our rights. So this is Donna Howard. She is the Women's Health Caucus chair, and she is our #1 champion for abortion access at the Texas legislature. And these are all of the other champions standing around her. I think oftentimes we think that the legislature is a hostile environment. It absolutely is to abortion access, but that doesn't mean that we don't have people who are elected representatives standing up for our rights every single day. We absolutely do. And this is such a great visual example of those people standing up for our rights on the floor of the legislature. Here's another great example. This is Gina Hinojosa, a great champion out of Austin, who was telling a personal story, which takes some real courage to stand up and talk about your pregnancies and your feelings about abortion in front of a state legislature that doesn't believe that you deserve that right. A couple more pictures from advocates and on the floor of the Capitol. This is Joe Moody. He's representative, he's former Speaker Pro Tem. His title, if you've been following the drama that is during the special session, was just stripped from him by Speaker Dade Phelan. And he is a well-respected advocate. He is a member that people on both sides of the aisle respect, but his title was stripped from him for standing up for the rights of Texans, and that includes abortion access. You know, a lot of information has gotten to the world about why they did this for voting rights, but there's further attacks on abortion rights at the special session right now, and the breaking of the quorum has been instrumental in further protecting the rights of to seek abortion in Texas. And people like Joe Moody and the rest of the Democrats are really standing up for our rights. Unfortunately, no matter we advocate, and it's important that we continue to do advocacy work, and important for you to show up and make your voices heard, but this bill was signed into law. This picture makes my skin crawl in a way that I cannot even articulate, I think, on this Zoom. To me, this shows a bunch of people who do not realize the gravity and the seriousness of the law that they just signed into Texas statute. That this is going to impact people's lives in a very meaningful and serious way, and they are making light of it by, making jokes and making heart hand signs, and this is just inappropriate and yeah, it makes my skin crawl. But we aren't going to let that stand, right? So that's why I'm going to show a little 30-second clip of us in the streets fighting back against abortion access. I want to say that this references women, and I wanted to comment that, we know that not just cisgender women need abortion access, but I thought that this was a really beautiful spoken word, and I wanted to show it to folks. And if you can't hear it, I'm sorry. I hope you can.
The lymphatic systems are the lakes and the waters. It is all the same. We are all one. When we heal our women, we heal our planet. You are the water, you are the moon. When we heal the waters, we heal the women.
So they were afraid of us, right? We had thousands of people show up at the state capitol to protest the bill, and this is a really good example of, like, if you can see here, there's a bunch of state troopers in the background ready to kind of descend on the crowd if they felt like things got rowdy, and there were snipers on the roof of the Capitol, but I think that this picture really just demonstrates, as well as the rally video, that we aren't going to back down, and that we believe in our rights, and our rights should be protected. And so we were in the streets. I hope some of you, if you were there with us, please put it in the chat. If you were at the rally, thousands of people were, but we weren't going to stop there, right? Which is why it brings us to why we're here today. We filed a lawsuit against many people, and we'll talk about that in just a second. And we just recently served them last week. When you file a lawsuit, you have to serve them. And this is just kind of a funny picture. This guy is Mark Lee Dixon. He is a defendant in the lawsuit. He has been traveling across Texas attempting to convince cities to ban abortion, which they cannot do legally because abortion is a constitutional right. And he was proud and ready to be served. And I have to tell you, we were ready to serve him. So with that, I'm going to invite the panel to, I'm going to stop sharing my screen and invite the panel to come on video. And I'm going to try to stop my presentation on my end so I can see things. Okay, so with us today, we have an amazing panel. We have Adriana Pinon, who is the policy and advocacy, or sorry, that's my title. Adriana is a senior attorney and policy counsel at the ACLU of Texas with me. We're close colleagues. We have Julie Murray, who's, Julie, if I'm saying your last name wrong, please correct me whenever you come on, but she's an attorney at Planned Parenthood Federation of America. We have Rupali Sharma, who's with the Loring Project and is an attorney, Molly Duane, which is with the Center of Reproductive Rights, and Alexander Lawrence, which is with our law firm partners at Morrison and Foerster. So we're gonna get things started. Again, if you have any questions for folks, please put them in the chat or in the Q&A, but we're gonna start with you, Julie. Can you tell us a little bit about what this bill is, what SB 8 is, yeah, what it does?
To be here today with everyone. Thanks so much for joining to talk about this important law. So as you've probably seen in coverage of the law, SB 8 bans abortion at roughly 6 weeks of pregnancy. So for context, that's roughly 2 weeks after a person would miss first miss a period, and is before many people even know they're pregnant. So if this ban were to take effect, it would likely block at least 85% of abortions that currently happen in Texas, leaving thousands of patients without access to care in the state. SB 8's ban on abortion doesn't have any exception for rape, incest, fetal diagnoses. Its only exception is for documented medical emergencies. And you know, this aspect of SB 8, the ban on abortion at 6 weeks, is comparable to other abortion bans that we've seen around the country that apply at the point in pregnancy before fetal viability. And every federal court to consider the merits of those bans has blocked them, and for good reason. They are blatantly unconstitutional under decades of Supreme Court precedent, including Roe v. Wade. So in that respect, SB 8 is more of the same, of state legislatures adopting laws that they know are unconstitutional. I think what's important to understand, though, about SB 8 are the ways in which it is different from other abortion bans that we have seen in other states. So unlike the bans that we've seen elsewhere, SB 8 bars public officials from directly bringing enforcement action to enforce it. So, you know, in other states, for example, if there's an abortion ban that has a criminal penalty, abortion providers have sued the attorney general or local prosecutors to make sure that they have a court order telling those officials, you cannot enforce this law. But what SB 8 has done instead is to turn over the enforcement to anyone in the public other than those government officials to bring their own lawsuits against abortion providers and anyone who helps a person obtain an abortion, and to conscript the state court system into these rigged proceedings in order to enforce the ban. So in terms of who can be sued under SB 8, that is also an area in which it's different from what we've seen in other states. Not only can an abortion clinic or a doctor who performs an abortion be sued under this law, but anyone who helps a patient obtain an abortion can be sued, or even intends to do those things. So the scope of people who could be sued under the law is extremely broad, and SB 8 effectively puts a bounty on those individuals. So not just abortion providers and their staff, but you know, a mother who accompanies her child or her adult daughter to an abortion provider for an abortion and pays for the abortion, a sexual assault counselor who might call a health center to help schedule an abortion for a client. Any of those people under SB8 could be dragged into a state court and sued for up to 10,000, or sorry, for a minimum of $10,000 per abortion in which they, helped perform or that they assisted. So the law is set up. One thing I wanted folks to take away from this presentation is that the way that SB8 is structured, it is targeted to be as maximally punitive, harassing, and draconian to anybody who helps a patient obtain an abortion, and to systematically isolate patients from the care and support networks that they need. And then the last thing that I would mention about what SB8 does, in addition to all of this, the ban, the bounty hunting enforcement provision of the statute, it also contains a provision that would apply going forward, not just to suits challenging SB8, but to any lawsuit that abortion providers or anyone trying to protect abortion rights files in the future against an abortion restriction. And it would impose massive, ruinous attorney's fees and costs on those individuals and their lawyers anytime they don't prevail on every single claim they bring. So again, it is another provision that is very clearly targeted to make it, as punitive as possible for anyone who is trying to vindicate civil rights. And with that, I'll turn it back over.
Yeah, thanks, Julie. I think the bottom line here is that this is meant to shut down abortion clinics across the state and make access impossible. And that is just something that we can't stand for, which I think is a great transition to Molly. Molly, why don't you tell us who we're suing in this lawsuit and why?
Sure. So as Julie said, this law is unique in terms of its enforcement mechanism, and Texas crafted the law this way on purpose, both to create chaos in Texas, which it's already doing, but also to prevent us from identifying someone to actually sue, to go into court and to stop this law from taking effect. However, as our lawsuit explains, state officials are still involved in enforcing SB8 and cannot shirk their duties and offload them entirely to private citizens. So we have sued those officials. First, we sued state court clerks who docket the cases that would be filed under SB8 and state court judges who hear those cases, as both of those individuals are responsible for enforcing the law just by virtue of the administrative and judicial roles that they would serve in adjudicating these SB8 cases. Second, we sued state officials who are charged with enforcing other Texas laws, not necessarily SB8, but other Texas laws that could be violated due to violations of SB8. And so those individuals are indirectly enforcing the ban. So the agencies that we have sued include the Medical Board, the Nursing Board, and the Board of Pharmacy. I'll note that the Department of Health and Human Services and the Attorney General are also included as defendants in this lawsuit. And that is due to a separate provision of SB8, which we haven't talked about yet, which sets up a punitive and targeted attorney's fees penalty for just bringing a lawsuit challenging an abortion restriction. And then lastly, as you already saw his lovely face, we have sued a private individual, Mark Lee Dixon, who's the director of Right to Life of East Texas. And the reason we sued him is that he may be the first, but it won't be the last private individual to threaten enforcement of SB8. In fact, just since we filed the lawsuit, we've seen other folks come out, including Texas Right to Life, issuing a statement, an explicit threat that they will sue providers as soon as SB8 takes effect, if it does. So certainly Texas has been creative with the drafting of this law, which means that we've had to be creative as well. But I think it's pretty clear from both the face of the law itself and from the way we've crafted the legal arguments that Texas cannot evade review in the court system just by virtue of writing the bill in a different and strange way.
Yeah, just a quick recap, and Ollie, let me know if you have additions. So I think a lot of people are probably wondering why didn't we just sue the head of HHS, or why didn't we just sue the attorney general? And the bottom line is they're not enforcing this law, right? That it's private individuals through these lawsuits, through this bounty hunting process, right? That is enforcing the law. And so we can't, right? We can't, the way that something very basic called standing is set up to be able to get into court, you can't, it's not as clear cut on who to sue, right? Foundationally.
Exactly. So unlike every other 6-week ban to have passed around the country, this one does not make it a crime. So you can't go to prison. The district attorneys, the attorney general isn't responsible for enforcing the law as a criminal ban. Rather, it's this private enforcement scheme, which is why we structured the lawsuit in the way that we did. Because in any lawsuit, you have to be able to identify someone on the other side whose activity can either be stopped or can be caused to take effect in a way that allows the harm that you are alleging to be redressed. So that's why we structured it in that way.
Yeah, thanks for that follow-up. Alex, over to you. Tell us, what are we doing in the suit? What does the suit say, and what are we claiming they're violating?
Okay, so a week ago we filed our complaint in this case, and to summarize, the complaint says that the law is unconstitutional, right? In each of our claims, we lay out exactly why the law is unconstitutional, and it's unconstitutional for a number of reasons. So there's a number of provisions of the United States Constitution that this law violates. And so I'll quickly go through them. And if you have any questions about it, you can circle back, but at very high level. Our first claim is that the law violates the 14th Amendment to the Constitution, the substantive due process right. And there's a basic rule that you can't ban abortion prior to viability. That's simple. And it's a rule that goes back almost 50 years. So that's exactly what this law does. So it violates the substantive due process right. We also have our second claim is one for violating the 14th Amendment's Equal Protection Clause. And at a really high level, what the Equal Protection Clause says is that all persons who are similarly situated should be treated similarly under the law. And what this law does, as Julie's explained, it basically sets out an enforcement mechanism where the deck is stacked against individuals who provide abortions or help those who need an abortion get one. So it sets up a punitive system that is unlike anything else under the law in Texas or elsewhere, that just punishes providers and people who help individuals get abortions. Our third claim is also under the 14th Amendment of the Constitution. It's a void for vagueness claim. And essentially, it says that the law fails to inform parties as to what type of conduct is being penalized here. It doesn't give guidance as to exactly what you do or may do and violate the law. And it essentially deputizes private citizens to go after providers and people who help others get abortions. We also have a claim, our fourth claim is for, it violates the First Amendment, right to free speech and the right to petition. This is also a violation under the 14th Amendment. And basically the law as it's constructed, it violates free speech rights and the right to petition by chilling expressive conduct. And the right to petition the courts. Our fifth claim is under the Supremacy Clause. And what the Supremacy Clause basically says is in this country, federal law is supreme. So where state law conflicts, it has to give way to federal law. And what this SB 8 does, it essentially instructs state court judges to ignore federal law. Rather than applying the rule that you can't ban abortions pre-viability, it says that you have to show that there's an undue burden. And there are other ways in which this law essentially runs headlong into federal law and conflicts with it. Our sixth claim is related to the fee shifting provision, which Julie discussed. So essentially, there's a section of the act which says if you ever challenge an abortion law in Texas, the other side can come after you and recover their fees. And you may have read articles about this. The state of Texas expends large sums trying to defend its unconstitutional abortion laws. And basically what the law says is we're going to let the attorney general, district attorneys, whoever it may be who's defending these laws to come back and ask those who are challenging them to pay the bill. And there's a federal law that basically says in federal court when you can shift fees, and this runs headlong into it. In addition to that, there is a last claim, which is claim 7, which is also under the First and 14th Amendments. It says this same law, which shifts fees, is intended to basically chill expressive conduct, the right to petition the courts. So when you can shift the bill to anybody challenging an abortion law in Texas, it's basically saying, don't do it because we will bankrupt you if you come into court and try to challenge an abortion law. So very high level, that's what the complaint says.
Yeah, so I mean, bottom line is they have violated the Constitution in so many different ways with this bill. I mean, there's not nearly as straightforward as it usually is. I think that that's the message we're trying to get out here, that they have really attempted to make an end run around the Constitution, around our basic systems of government, and our complaint essentially calls them out on every single step of the way of that, right? So it's not just that this is not just about abortion. This is about, you know, how we govern ourselves and what the Constitution says fundamentally. And I think can have a real big impact beyond the abortion world and within it, obviously. And that brings me to Rupali. Can you talk to us a little bit about what what SB 8 specifically could mean for the national landscape and what this lawsuit can mean for the national landscape?
Sure. So if SB 8 were to be upheld, it would be the first pre-viability abortion access ban upheld ever. And it would contradict over 50 years of precedent, and it would really make a mockery out of countless Supreme Court decisions. And presumably, if it were upheld, it will be because of what we've been discussing thus far, which is that Texas has succeeded in doing underhandedly what it can't do directly, which is deny people a right to abortion before viability. And again, as we've been discussing, the way it's doing that is that it is on the face of the law preventing the government from enforcing the law and deputizing private citizens, private individuals, private organizations, whether they are opposed to abortion access or whether they just want to harass and penalize abortion providers and supporters and bring lawsuits against them. And it will have done so by really upending the rule of law. So I think we've been discussing the enforcement mechanism aspect, but we've also touched on the fact that when these private lawsuits are brought against abortion providers or supporters of abortion access, there are numerous ways that those lawsuits themselves contradict the rule of law. So, you know, you can't rely on the federal undue burden protection. You will have to defend yourself possibly in several venues across the state at the same time. You can't recover attorney's fees. And so if the ban is upheld, it really will really just completely overturn just numerous legal protections that we've come to rely on in abortion cases and outside of them. And I think what you'll see nationwide is this law proliferate. You'll see it in all the states that I think, as you said, Drew, for over a decade, have really been contrary to their people's interests, restricting abortion access, layering barrier over barrier to really target the most vulnerable folks in their states. You'll see an SB 8 in each of those states pretty quickly. I think what you'll also see is that this strategy or this set of strategies isn't limited to abortion access. And when we represent patients and providers and the clients who our abortion funds support and assist, we know that abortion is and pregnancy and reproductive healthcare access is one aspect of their life, and there are so many rights that really make their lives, give them respect and give them dignity in their lives. And I think what you'll see in these other states is legislatures using this set of strategies to restrict all sorts of rights. So we know that voting rights have been under assault for years now. You can see the same strategy used against voting rights. You can see the same strategy used against marginalized religious communities. If the majority of a state decides to attack them, they can do that using this set of strategies. You could see the set of strategies deployed against LGBTQ folks. And so I think there really is no limit to the harm that this could do. And so I think it's important not only for folks who firmly believe that people have a right to bodily autonomy and to decide what to do with their pregnancies and decide how to build their families, but people who believe in individual rights and people who trust our legal system and have come to rely on it as a way to safeguard those rights against hostile majorities and folks who aren't willing to stand up for marginalized folks. And so I think, in addition to really understanding it as an attack on abortion access, I think we need to step back and really understand it as an attack on the legal system and other fundamental rights.
Yeah, that's scary, right? Everything you just said has really put a chill in my heart. It is the foundation of our country that we can rely on our constitutional rights. It is kind of embedded in our framework and also our narrative that we tell ourselves. And if we can just undermine it by playing essentially, by playing fast and loose with the rules in this way and have these laws that are able to go around it, it really just makes me worried about our future in a way that I don't think really anything else has. Lots of things make me worried, but this one really hits to the heart of it. Adriana, why don't you bring us home to Texas? Tell us about what would happen if this law goes into effect and how this will impact our communities.
Sure. Hi, everyone. My name is Adriana Piñon. My pronouns are she, her, hers. And you've heard already Drew mention how difficult accessing abortion care is in Texas already because of the needless restrictions and unconstitutional laws that have been passed. If SB 8 were to take effect, it will push abortion care even further out of reach. So, you know how big our state is. If this law goes into effect, some clinics, when faced with the ruinous liability that this law creates, may force to shut down. If they choose to continue, they will then be faced with staggering damages and from multiple lawsuits, right? Which in the end will force them to shut down. So what does this mean for accessing care? It means that there will be fewer people who will be able to provide the necessary abortion care that Texans need. It also means that the costs associated with accessing that care will also be greater. Texas, among its many restrictions, has already prohibited paying for abortions through Medicare, through state insurance plans, and most private insurance plans. So this will take away another very needed avenue for people to be able to afford to pay for an abortion. And this, I think, brings me to my other point, which is the people who will feel the brunt of the harms more in Texas will be our communities of color and our communities that are already struggling to make ends meet, right? Folks who are dealing with very difficult situations of, paying rent, paying bills, paying childcare, now will have to pay more to access basic high quality care. And as Julie mentioned, the support networks that a lot of people rely on to access care, including financial support to access care, are dismantled by SB 8. So it puts further hurdles in the path of people who are already struggling. Some may not be able to overcome those hurdles and may have to carry pregnancies to term, which, the consequences of which could be disastrous. And in particular in Texas, due to years of racist economic policies, the people who face poverty greatest are Latinx and Black Texans, right? The poverty rate among Black women in Texas is 19%. It's 20% for Latinx women. Among female-headed household, the poverty rate is 37%. So these folks are just going to have additional hurdles imposed to accessing high quality care. This is going to exacerbate the existing disparities in access to healthcare and what that means, for people who need high quality care. For example, Texas has one of the highest maternal mortality rates among Black Texans. These harms that SB 8 imposes will only aggravate those harms, and it is, as everyone has been underscoring, a law that is exceedingly punitive in many respects, but it is especially punitive to our communities of color in Texas.
Yeah, thank you, Adriana. I mean, I think the bottom line for us here is that we know that people are going to always need an abortion, right? People always look to get abortions, have been performed or been sought for essentially since people could become pregnant, right? Since the beginning of time. And so this law is not going to stop abortions in Texas for people of means, people who can leave the state to get an abortion that they need, but it will impact people who don't have the means to leave the state, who are already marginalized in our communities. And it's going to push like basic healthcare access out of reach for those people. And so it's really hard to underscore how important it is that we win this lawsuit and that we ensure that access remains in Texas. So I want to do a quick round the horn before we get to the Q&A. If everybody could end the formal panel on a positive note. Why is this work important to you? Why is it important that we fight for our rights and in Texas and beyond? And I will go ahead and start to my direct right, which is Molly, and I'll go around the horn.
Sure. So, I mean, my positive note here is I've been a lawyer at the Center for Reproductive Rights for around 6 years, and I've spent most of that time litigating in Texas, which for me is familiar territory because I am from New Mexico originally. So, I think what inspires me every day is getting to work with Texans and providers who are some of the most courageous people I've ever met and who never stop fighting for their patients and for the populations in Texas that need them most. And so that's what really inspires me every day.
Julie, you want to go?
Tamale. I think I work at Planned Parenthood Federation of America, so I represent affiliates around the country, and oftentimes, given the nature of the litigation work with our affiliates who, are in very hostile states to reproductive rights. And I think being able to work with the doctors, nurses, medical directors, other staff who are on the ground every day and are keeping health centers open for people is just an incredible, it's an incredibly meaningful way to spend our days. And I think Molly and Rupali as well, we were involved last year in the COVID, litigation over the COVID ban in Texas, and, saw firsthand with our clients what happened to patients when there was no access to abortion in Texas. And I think that it is motivating going forward to make sure that we are able to get people the high quality healthcare to which they are constitutionally entitled in Texas.
Yeah, thank you. Adriana?
So I've been working for the ACLU and different affiliates for my entire legal career, and this work is important to me because I believe strongly, as I think all Texans do, in liberty, in being able to structure one's life the way one chooses, and that includes being able to make decisions about your bodily autonomy and getting the government out of those spheres where it has absolutely no business being. So to me, it is important to push back on this law because this law basically flies in the face of all of those beliefs that I think are important.
Yeah. Rupali?
Thanks. I think I originally started doing this work because I always felt that abortion access and reproductive health care access in general, and so, even apart from the law, but just practically whether people have access to meaningful care was a good measure of how states and other people view them and how much they respect them. And I think a law like SB 8, which I think Adriana really eloquently summarized, really targets poor people of color and really tells them that they are not worthy of meaningful care and respect and dignity. And I think what everyone has touched on is that we work day in and day out with people who refuse to believe that and refuse, despite the law, but despite states trying to codify it right into law, refuse to believe that about themselves and about their families and know that they're worth something more. And that's incredibly powerful and inspiring. And I think I just share in everyone else's sentiment that I feel really, really privileged to be able to work with them on that.
Yeah, thank you. Alex, round us out.
Sure. So I come to this, when I was a kid, my grandmother represented the abortion clinic in my hometown in Tennessee in a 15-year struggle to keep it open. And, I remember like protesters outside her law office, and I was like, sign me up. That's for me. So, and like Molly, I've been 10 years fighting these laws in Texas, starting with the sonogram law, HB2, the D&E ban, fetal tissue burial, and really there's no law that's more really chilling than this one, because it obviously it will ban abortion in the state of Texas, but it also fundamentally subverts the rule of law. It's frightening.
Yeah, so I am so excited about the amount of questions that we got. We hardly ever get a million questions, and we do have a whole bunch. So we're going to try to get through as many as we can. If we don't get to yours, I'm really sorry, but I'm going to kind of put them in random order, and we're going to start answering them. So the first question I want to have answered by the panel is, what happens while this lawsuit is in play? Will the law be able to be rolled out in September, whether or not the suit has been decided by then? So what are we going to be able to stop this before September and having it go into effect? I think is the bottom line here. Who wants to take it?
One thing that we haven't said today that is an important point for people to know and to share with your networks is that abortion is legal today in Texas. Our health centers are open. They are providing abortions, and we intend to keep it that way. We have asked the judge to rule before September 1st, as far in advance before September 1st, so that there is no disruption in care, because we know that abortion cannot wait. So that is our goal, that there be a court order in place before September 1st to protect and permit services to go forward.
So here's another common question. Can Texans who help people access abortion out of state be sued under SB 8? Does anybody really want to take this one? Molly?
I can give it a shot, sure. So the question is, folks who help patients access abortion outside of the state of Texas, can they be sued? I mean, the thing that's really pernicious about this law is that it leaves enforcement up to third parties, who could have any number of theories about who is and is not liable, which may or may not be related to the actual language of the bill. I think that's a tough question. Our read of the law is that it would be impossible to hold someone accountable for activity that happens outside of the state. There are, lots of rules about how the state of Texas can't order the state of Mississippi to do certain things and vice versa. So I think it would be challenging, but what really is the takeaway here is that this law is so evil because it leaves enforcement up to third parties who can decide for themselves what they think the law means and drag any number of parties, be they directly involved in abortion care or indirectly, haul them into court and deal with frivolous lawsuits, which fly not only in the face of patients' access to abortion, which is protected by the Constitution and has been for 50 years, but any number of other constitutional violations, which we have alleged in our complaint in this case.
Molly, I think there's another question that kind of piggybacks on this a little bit. What is it going to look like? You mentioned that it's going to be up to the individuals filing these lawsuits to kind of interpret the law for themselves and see how it goes. What do you think what is this going to look like for clinics? Are they going to get a flood of lawsuits? Is it going to be, what do you think is going to happen exactly?
So I've spent a lot of time thinking about this, as have all of the attorneys and I'm sure many others in Texas. And unfortunately, I don't have a crystal ball and cannot predict the activities of people who are, on the scale of rational to irrational. My guess personally is that, there are a number of organizations and entities in Texas that have gone after abortion providers for decades. I mean, as Alex laid out, these cases go back, many, many years, and this is just the latest iteration of that long-standing attack, albeit a much more aggressive one. So I think it's entirely probable that a flood of lawsuits will come in. Now, how many lawsuits that will be, I can't predict, but I can say that we are preparing for the worst.
Yeah.
Can I add one point to that? One thing that we didn't touch on, but I think it's important to understand about the impact of SB 8 is that if it were to take effect, not only would it allow effectively an unlimited number of people to bring lawsuits and really face no consequences for that, because they can't be held liable for the attorney's fees and costs of the other side who they are frivolously suing. But it would also prevent the abortion providers and other people from who are sued from trying to bring those cases together or to move them to a more convenient forum. So you could have an abortion provider in Houston, for example, who is sued in El Paso over an abortion that didn't occur there, the patient didn't live there, and the abortion provider has never lived there. But if a citizen of El Paso wants to sue them, SB 8 would permit that. And so it is designed to have an explosion of cases and to impose maximum costs on the people who are sued. I think every indicator, based on what we know of individuals opposed to abortion, their tracking of abortion providers, their targeting and harassment and filing of false complaints in the past, there is every reason to believe that people will bring suits and there will be lots of them.
Yeah, kind of a part of this conversation is also another question about how will people know when the law has been violated with HIPAA and other regulations about people's private medical information, how are people going to know? I think really what you said to me just now, Julie, is they may not know, right? But people bring harassing lawsuits all the time for abortion providers, but I don't know if anybody else wants to pick that up, that thread up.
I mean, I think one thing I'll just add to that is just to remind folks about the aiding and abetting provision, in addition to the fact that the law criminalizes constitutionally protected performance of abortions. The Loring Project represents the abortion funds and practical support funds in the lawsuit. And what aiding and abetting traditionally means doesn't matter, because SB 8 encourages folks to sue people for supporting abortion access and supporting particularly low-income folks' access to abortion. And so, I think, Drew, you identified it. People don't need to have a good reason. They don't actually need to have evidence to bring a lawsuit. And even bringing the lawsuit for organizations and individuals who are already under-resourced and have already been fighting restrictions for years is enough to bankrupt them, which means that they can no longer operate, which means that the folks that they provide funds and practical support to are no longer going to get that assistance. So it's really, I know everyone's been touching on this all morning, but it's really a law that's designed to target every possible entrance point to safe abortion care.
Can I mention the Lubbock, what's going on in Lubbock? Because I do think it's important for folks who are trying to understand potential impact. There was a law very similar to SB 8 recently adopted by the city of Lubbock. And Planned Parenthood Greater Texas operates the only abortion providing center in the city of Lubbock. It was directly targeted at Planned Parenthood. And we are litigating currently over that abortion restriction, but we're unable to get it blocked before the effective date. The morning that it took effect, our call center received calls from anti-abortion folks trying to test whether there was an ongoing offering of abortion at that health center. And the result of that law is that at this time, we are not able to provide abortion in the city of Lubbock, and residents there are traveling roughly 5 hours each way to get an abortion. So I don't think we can understate the impact that this will have on access to abortion if we are not able to block it.
Yeah, we have one more, I think we have time for one more question, and one just came in that I think is really important. And then I'm going to answer everybody's question about how to get involved and how to do more, which a lot of questions came in for that. So really this last question was, can somebody who is a perpetuator of sexual assault, somebody who rapes someone, sue under this law? And like, what is going to be the impact of this law on sexual assault survivors? And I think this is a really important point, so I want to get it out for the end. So does anybody, who would like to answer? Julie, go ahead.
Julie's hobby horse, so.
Yeah, I don't mean to monopolize. So the answer to the question is that SB 8 states that the person suing over a particular abortion cannot be the person who caused the pregnancy through a crime. So a rapist, in theory, cannot sue to prevent the abortion of a pregnancy caused because of that rape. There are, of course, problems with that, huge problems. One is how would you possibly know in advance? In order to know, are you going to force patients to intervene and make public a trauma in their lives? And then the third thing to note is that even if, aside from those individuals, SB 8 would still permit abusive partners, manipulative parents to sue abortion providers to effectively block a patient's abortion choice. So it is absolutely, in addition to the egregious nature of this enforcement mechanism, it very much leaves open the doors to people who, really are trying to block a particular patient's abortion choice. And that can include individuals who, partners who are abusive. It could include the parents or family members of rapists, people who have caused pregnancies through incest and other crimes. It is extremely horrifying to imagine how that could apply.
Yeah, this is really the most traumatic. I mean, we're really living in a dystopian world in so many ways, where we're allowing people who are worst actors to profit off of that action, right? Don't forget that these people get a baseline of $10,000 if they win their suits. It's just, it's out of control. So I think, Adriana, 5 seconds, we're like at time.
I was just going to say, it also, for the survivors, right? It dismantles the support that they need in one of the most difficult times that they're going through. And I think that's one of the many, many ways this law is so ugly and hurtful.
Yeah, absolutely. So if this has convinced you to get involved in the abortion rights movement in Texas, and I hope it has, because we need you now more than ever. We know it's going to take all of us, the attorneys in this room, the advocates that I showed you earlier, supporters like you, to get involved and to stand up for our access to abortion. I encourage everybody to go to TXAbortionAccessNetwork.org. That's the Texas Abortion Access Network. The Texas Abortion Access Network is a collaboration of Texas abortion advocacy organizations who have come together to recruit and train people to be advocates in your community. So we'll give you all the tools you need to be a spokesperson, to advocate at city council. Somebody asked about the Edinburgh city council vote tonight. The city of Edinburgh is going to try to ban abortion, and we're fighting back against it through the Texas Abortion Access Network. So we mentioned Lubbock. That has been a huge Texas Abortion Access Network project. This is really the place where if you want to really get in the weeds and get an idea of how to really advocate for abortion in your community, please join us there. We'll also send you updates. If you're already on our mailing list, we'll send you updates to contact your members,